welcome to today's webinar, E2 under heightened scrutiny, US CIS and embassy trends. Thank you so much for joining us. My name is Gerald Padilla, and I'm the Vice President of Sales for the US market here at Journey. For those who are new to Journey, we specialize in creating business plans and supporting documentation for immigration professionals and their clients. Now, if you've been handling E2 cases recently, you probably noticed something. The adjudication environment has changed. What may have worked 2 or 3 years ago isn't always working today. USCIS and USCIS and US embassies are taking a much closer look at business plans, financials, marginality, and whether businesses truly are operational or just a concept on paper. More RFEs, tougher interviews, higher standards for credibility. That's exactly why we're here today, to help you understand what's changed, what officers are scrutinizing the most, and how you can prepare stronger filings that hold up under today's challenges and standards. I'm thrilled to be joined today by Bobby Chung, an immigration attorney who focuses exclusively on E2 investor visas. Bobby has extensive experience representing foreign investor v matters involving both newly established entities and an acquisition of existing businesses. Proudly, we've worked with him and his amazing team on many successful cases for almost a decade now. Before entering private practice, Bobby served as an attorney advisor with the U.S. Department of Justice, Executive Office for Immigration Review, where he assisted federal immigration judges in adjudicating immigration cases. Bobby brings a unique perspective to today's conversation, not only as a practicing attorney, but as someone who has seen the adjudication process from the inside. Bobby, thank you so much for joining us here today. We're really looking forward to this conversation and very excited to have you here. Thank you. Before we dive in,
thank you, Gerald.
You're very welcome, Bobby. It's a pleasure. Before we dive in, I want to let everyone know we'll be taking questions towards the end of the discussion. You can submit your questions at any time in the Q&A chat on the right, feature in our webinar platform, and we'll do our best to address them towards the end of our discussion. You can earn one CLE from the Florida Bar by attending this webinar. I'll mention those CLEs towards the end of the webinar to make sure you're all still here and awake. But for now, let's get started, Bobby. Let's talk about what's happening in the E2 cases today. How are you today,
Awesome.
Bobby?
Excellent. Excited to be here.
Fantastic. I know we've known each other a long time, so I'm very excited to get this conversation with you. I know we've had a lot of conversations about E2s, and I know you have quite a bit of valuable insight to share. So I guess let's get to it. So I guess we'll start with the landscape shift. From your recent E2 filings, how would you describe the overall shift and how US CIS and US embassies are reviewing business plans compared to 2 or 3 years ago?
Great question, Gerald. There's definitely been a shift over the last 12 months, I've noticed. With respect to business plans, I've noticed adjudicators are less willing to assume the veracity of the projections and estimations without corroborating evidence. So it really has the projections and the assertions in the business plan really needs to make sense in relation to the investments amount, the business size, and the business development progress. There needs to be corroborating evidence substantiating all the facts and data and projections in the business plan now.
Yes. We've been seeing that also on the business plan side, definitely on the revision requests and the kind of details that need to be put in nowadays versus the past. Are you seeing more scrutiny at the initial filing stage, or is the initial questioning showing up more on the RFE side, interviews, renewals, counselor process?
I'm seeing greater scrutiny through the whole spectrum of the E2 visa process, whether it's initial filing or renewal or through the RFEs or at the interview stage. The questionings are more extensive. I'm seeing the questioning go into the individual profile of the applicant equally as much as about the business investment and marginality and the business viability. So now as an attorney, we really have to scrutinize the applicant's personal profile in terms of where they're from, their travel history, whether they've gone to any of the travel banned countries, whether looking at their resume, whether they have any background their profession or their education, where they have experience in dual use technology that could be seen as a security threat, how much family ties they have in the United States, and how their family immigrated to the United States, so on and so forth. So we have to do an equal amount of vetting of the applicant's personal profile in addition to advising them on making a qualifying investment.
I mean, along those lines, do you think officers today are focusing more on the credibility of the business or the applicant in itself? I mean, has the line effectively disappeared, or is it kind of a unified thing?
The line has disappeared. I feel like the individual profile is equally important. I've seen interviews, counselor interviews, where the questioning was just solely focused on the applicant's personal background, family ties, career, where they've traveled. Sometimes the applicant may be dual nationals, and their other nationality or where they were born is in one of the travel ban countries, and the interview end up not being anything about the business. So it just goes to show in the last 12 months, the emphasis on the security vetting of individual applicants. And now our questionnaire and our client due diligence has to focus a lot on the individual background, in addition to making sure their business setup and investment presents a strong E2 case.
See. Okay. Are you hearing more about officers challenging whether the business is truly active or operational, or what kind of evidence or plan details are officers looking for nowadays? Is it to avoid perception or paper
Definitely.
enterprise? Yeah. Yeah. Okay.
Definitely. Paper enterprise tend not to work anymore. It's become, the scrutiny has definitely increased. So I almost see like the business plan as a blueprint, a cover letter almost, and it asserts the potential of the business and the accomplishment the applicant has made in establishing a real business in the United States. But now all that those assumptions, all those pronouncements has to be backed up by real evidence of contracts, expenditures, business development progress, you know, assertions of the business is going to make millions of dollars. The big question is, how is that going to happen? It has to align with reality. What kind of business development efforts and accomplishments has the applicant done to substantiate that kind of projections? So a lot of times our clients are entrepreneurs, so they're going to be really excited and optimistic about their business and the potential, which is great. I'm all up for that. But a lot of times I have to dial them back and um, explain to them that we are presenting this case to a target of one adjudicating officer who may not share your enthusiasm and outlook on the potential of your business. So we have to make sure every detail of the business plan projections look credible from an objective person's point of view in order to convince them that your whole venture is credible, and that they are willing to take that leap of faith in trusting the projections and give you a chance to carry out your business plan. If they feel you're not realistic, they may very well just simply discount the business plan, discount the projections, because I've seen denials where the business plan looked beautiful, projections are great, job creation is great, and they get a 214B denial with little to no reasoning. And a lot of time it's simply lack of credibility.
Okay. And we just got a comment here in the QA. Just, I guess they'd like a little bit of clarification to distinguish between USCIS and consular processing, since it seems like there might be some differences between the two nowadays. So yeah, we'll be sure to specify that. Thank you, Andrew. Um, And along those lines, as far as adjudicators pushing back, I mean, how are they distinguishing between speculative and credible growth? Because we've definitely seen that when it comes to, where we create the business plans and the financial projections. And how do we distinguish between, yes, speculative and credible growth?
So it all comes down to the progress and accomplishments of the business as presented to the adjudicating officer. So if, for example, if it's an e-commerce business, for example, and the projection is the business going to make multiple millions of revenue. The question is, how is that going to be accomplished? You can't just make a simple pronouncement. Simply stating you're going to do online advertising, online marketing is not sufficient. It needs to be more clear than that. Has the advertising actually converted a critical mass of customers wanting to buy your product? Has your marketing system proven to be true? Do you have a social media following of your product and services or your brand? There has to be something substantial. If you're doing import business, distribution business, wholesale business, are there distribution agreements that are signed, executed? Do you have wholesale contracts signed and executed? Do you have purchase orders? You have demonstrated meaningful customer interest in your product? So there has to be a critical mass of evidence to substantiate those financial projections.
And how closely are the officers comparing, I guess, the business plan to the actual filing materials, such as source of funds, bank statements, lease agreements, corporate documents, and how critical is consistency across all of them?
Consistency is super important because consistency results in credibility. If they see any inconsistency and they feel like the business plan was written in isolation from actual investment, they're going to discount the business plan. So everything needs to line up. In terms of like in the business plan where it talks about the investment spending, the investment amount, all that needs to correlate with detailed evidence of actual investment spending, not just invoices and receipts, but actual proof of payments and the payments correlating to the receipts, everything lining up and consistent. And that's why we work closely with Journey writers to make sure that everything, all the data points in the business plan are aligned and fully consistent with what we present in the attorney cover letter in the supporting evidence.
I mean, have you seen or noticed any differences between the US CIS and consular processing at US embassies, particularly given the page limits for the E2?
Definitely. And even though the E2 visa regulations are same or similar between US Consulate, Department of State versus US CIS, these two different agencies behave quite differently. Historically, it's not just recent time, historically, they've had different emphasis. With the USCIS, their emphasis has always been high scrutiny on source of funds and validation of the expenditures. With the USCIS, as you all know, there's no page limitation. So they expect quite extensive detailed evidence of all the expenditures. And even going into documents, how the description of the expenditures are written and how the fund transfers, how everything lines up, and there are no cash transaction, everything verifiable by bank records. Heavy emphasis on the source of fund, trail of money, proof of expenditure that ties to the qualifying source of the money. USCIS is just incredibly strict on that. Whereas with most US consular posts, most of them have page limitations. So due to that, you're not able to include the detailed documentation. And as a result, their focus, just from my many years of experience, 25 years so far focusing in this area, most of the consular posts seems to focus on marginality, business viability. They don't have the kind of detailed documents on source of funds and the trail of the money due to the page limitation to impose that level of scrutiny. Now, of course, I've seen cases where they issue RFE or 221G requests for more detailed evidence of the source of funds. Those are relatively rare in my experience. Seems to be they focus tremendously on non-marginality and active and operating business at the consulate post.
And do you want to expand, I guess, on your approach to those type of things and maybe examples too? I guess the two directions.
So with the USCIS, there is heavy emphasis on making sure from day one, the source of money is vetted and qualified, and the transfer of the money, U.S. enterprise, is carefully strategized. especially from countries where there are difficulty in transferring funds out of the country, or there are foreign currency export restrictions. And as well as like money coming from third parties, from donors or lenders, making sure the money comes into the applicant's personal possession and control before investing in the U.S. business. So vetting all that before the client even starts setting up the business in the United States, or work on searching for businesses to buy in the United States. The financial vetting is super important if the intention is to apply for a change of status in the United States. Whereas if the client is applying for an embassy E2 visa, I have a heavy emphasis on making sure the client understands, and it varies depending on the consular post, because high scrutiny consular post, for example, Pakistan, some of the US embassy in Middle Eastern countries and South America, they are much higher scrutiny than some of the US embassies in Western and developed countries. Even though all the rules are the same, they have such different personalities. So based on experience, I will advise the client and strategize with them that for your consular post, you need to make sure that the business on a non-marginality, active, real, and operating, because they're not going to accept, based on my experience there, an early stage, small startup speculative business. They're not going to assume you're going to do all that unless they have credible evidence that your projections are credible and realistic. Whereas some of the consulate posts in Western developed countries, for example, one of my favorite ones is Toronto U.S. Consulate. They seem to be very fair and open-minded, and I'm more willing to submit an application there for an earlier startup business, because they seem to be more willing to give applicants, entrepreneur, a chance to prove their business concept without a lot of business results already proven. So you really have to look at what consular posts you're dealing with. And nowadays, with the current administration's policy that applicants must apply for U.S. visas in their country of citizenship or residence, there's no more really third country national applications anymore. You can't really form shop. You're stuck with a country where you have citizenship or residence. In fact, I inquired for clarification with the Dubai U.S. consulate, because there's, even though UAE is not a treaty country, there are a lot of treaty nationals residing in the UAE. And I clarified with them, what do you guys consider to be a resident of UAE? My client has the UAE Golden Resident Visa. Their response to me is, it's not enough you have a resident visa. You need to be physically domiciled in the UAE to qualify to apply for your E2 visa here. So, this is how they're defining it. And then we have a clear understanding of where we are allowed to apply for the client's E2 visa. And then really look at that consulate at their level of scrutiny and their expectation, and build a case around that to satisfy that particular consulate post.
Amazing. Thank you for that detail. There's quite a bit of questions here going on about on the QA about specific consulates and approaches there, and if there's any kind of differences. It sounds like you talked a little bit more about those trends that you've been seeing. But of course, we'll answer a little bit more Q&A and get the specifics a little bit towards the end of our conversation. But that gives definitely a little bit more color on the different consulates and guess how some are a little bit more strict than others. And of course, under this new administration, what has changed in those regards. So, and going back to, I guess, the financials and marginality. But financials are the most challenged areas, as you can see, as you know. What inconsistencies are officers flagging most frequently now?
Gerald, can you clarify that question? What inconsistencies are the officers focusing on?
Yes. Well, we know that financials are really being challenged right now. And what inconsistencies, I guess, are officers flagging most recently? What are the red flags and those inconsistencies as far as in financials, whether it be,
Yeah.
yeah. Was that a little bit
Okay, I
clearer?
think I understand what you mean.
Yeah.
Yeah, I think I understand what you mean. So there are different contexts. So there's context where it's a brand new startup. So everything is projection on future potential, financial projections. There's also the context where a client is applying for a renewal. So you have the projection of the future 5 years in relation to what the business has actually performed. You also have the context where the client is buying an existing business and they have we show the performance under the seller, and then we project the financial performance for the next 5 years under the E2 applicant's ownership. The different contexts, there's different strategies and how the inconsistency play into that. So if, for example, the client is purchasing an existing business and it's borderline marginal, I see a lot of this buying borderline marginal business because that's where they get the best deals. And then they're projecting the 5-year financials on top of that. We have to be really careful on the projections because, of course, the client is seeing all these great potential and they're projecting this huge growth in revenue even after the first year they take over ownership. And the question from an objective adjudicator's point of view, how in the world is that going to happen if the owner, the seller, has been owning and running this business for a decade or 2 decades? What are you going to do that's so dramatic that's going to grow the business double? So sometimes I have to ask a client, and with the help of Journey, to dial back the projections because it's not only unrealistic to achieve that, you're kind of setting yourself up for failure down the road. If you project something really high and your actual performance is actually a lot lower, when you're renewing the E2 visa, it is much better to overachieve your projection than underperform. It's all a matter of context. So it's almost better to be conservative with your projections. And something that I thought would never happen in an RFE one time that really taught me a lesson. In an E2 renewal case, we receive an RFE asking for a copy of the business plan that supported the previous E2 application because the officer wanted to look at the projections in the prior E2 application and compare it to the real results in terms of financial performance and payroll projections, job creation projections. And thank goodness, because I've always been very conservative and careful, and I've always advised clients to dial it back to make at least the first couple of years conservative and safe. Better to overperform than underperform. And then when we submitted it, and that was the first time I got that kind of request, thank goodness we hit the projections for year 1 and 2. But I was thinking, oh my gosh, had the projections been very aggressive, we would have looked really bad. So we can't assume that they will never reference back to the previous projections. And then what they're doing is looking at the credibility. If your projections were actually materialized and realistic, that makes it easier for them to believe in your next projections for the next 5 years. But if you were way off, then that really hurts the credibility on whether they should even believe your new business plan anymore.
Yes, we've seen that in projections, and I see your comments quite a bit. And we know that it is always better to under promise and overperform than under promise and over deliver in those kind of cases. So I guess marginality remains a key E2 issue. What signals a business plan to trigger those marginality concerns about adjudication, and both in initial filing and renewal?
Yes. So marginality is basically relating to the contribution to the U.S. economy, and most commonly through job creation. And so they need the context is very different between a initial E2 application and a renewal. With renewal, they're looking at what kind of job creation have you materialized. And it's not just about the number of employees. They're looking at holistically whether in totality your business has created meaningful jobs for the U.S. economy. So we got to consider not just the number of employees created or hired, but the type of wages and salaries, and whether they're full-time or part-time, and are they professional or minimum wage occupation, the total payroll for all the staff. We have to analyze all of that to determine whether meaningful jobs has been created. And hopefully they have been created during the initial E2 visa duration. And then, of course, we project even greater job creation with the correlating the business growth. But sometimes, especially like during COVID, when a lot of business were negatively impacted and the job creation plummeted, payroll plummeted, what I've experienced in those situations is that if you can explain the circumstances beyond entrepreneur control that had a negative impact on their job creation or the marginality issue, um, adjudicating officer typically will be understanding about that, because I've been practicing long enough where I've been through the dot-com bust in 2000 and the 2008 to 2012 global financial crisis and the COVID pandemic, where many of my clients suffer greatly during those periods of distress. What I've found is that adjudicating officers a lot of times are understanding and forgiving of declines due to factors beyond the client's control. But you got to go beyond that and show how you're going to recover, and that your strategies to recover are materializing and are working, and that the future looks promising at the time applying for renewal. So that's a critical strategy to get the renewal approved when there is serious marginality issues during the initial E2 visa duration. On the other hand, if it's the first E2 application, it's a startup business, early stage, maybe you haven't hired anybody, maybe you haven't generated $1 revenue, maybe you haven't acquired a single client. There's a serious marginality concern because the business is so darn speculative. We really need to analyze, is that consular post likely to be open to this type of this early stage of a business development progress? Sometimes, and there's many factors that influence that. You're looking at the size and scale of the investment. The larger the investment, what I've noticed, the more the adjudicators are willing to take that leap of faith and trust in the potential. The smaller the investment, the more skeptical they are on the potential success. Thereby, you need to compensate for that skepticism by showing more business development progress, traction, and results. So it's a correlating effect. And the scrutiny of consular posts obviously plays significantly into that. So the strategies are extensive, and it really needs to be customized according to unique circumstances of the client situation, as well as whether we're dealing with initial E2 or renewal, or are we doing a startup or acquisition of an existing business that is borderline marginal or already strongly performing.
And I think you answered a little bit of part of this question, but a little bit earlier. But in your experience, what's the biggest mistake attorneys make and applicants make trying to strengthen their financial projections, especially when projections look overly optimistic?
Yeah, so it's not a good idea to be too overly optimistic, because it really hurts the credibility. But like in terms of general overall mistakes, the biggest mistakes I've seen are folks that start investing their money before consulting any immigration attorney, before getting any proper legal advice. And they do make some serious mistakes with cash transactions, improper fund transfers, direct transfer into the business from third parties. And then as a result, the whole E2 case has been sabotaged to the point where even if the business idea is great, business is very promising, if you're applying for a change of status, I already know the USCIS is going to be all over those bad transactions or cash transaction or unverified improper transfers. And no matter how strong the business looks, if they're not happy with the source of fund or money transfer, they will deny the whole thing on that point alone. So that's one of the biggest mistakes I've seen. I always advise clients, like, please allow me the opportunity to guide you from A to Z. If you're serious about doing this the right way and minimize risk, try not to do anything, because, and it's not your fault. You don't know all the ins and outs and nuances of E2 investment requirements. A lot of it is not even written in the regulations. For example, the regulation simply states the money must come from lawful sources, cannot be from criminal sources. But the reality of that is far more complicated, far more extensive. So basically, before they even get into business setup, having the financial due diligence and strategizing with the attorney, I think is super critical, and that it doesn't get done nearly often enough.
Thank you, Bobby. And are officers questioning how quickly a business plan can realistically support investors' employees, and how should plans address timing expectations, particularly with an eye towards future renewals?
Definitely, definitely. So I mentioned earlier that you want to be conservative with your projections so that they are credible, right? On the other hand, on the other end of the spectrum, you don't want to be so conservative where the officer feels like this business is weak, is puny, it's not going to make any meaningful contribution to the U.S. economy. So I've had clients take it to the other extreme where they project, well, I'm not really going to hire anybody for 2 years. I'll have a part-time employee by the third year, and I'm just going to be the service provider for the first year and second year. Like, for example, a hair salon business where the entrepreneur is going to be the hairstylist for the first year, second year, and then start hiring people in the third year. That's a big negative as well, because then it looks like a quintessential marginal business where the E2 entrepreneur is simply creating a job for him or herself in the United States, and that's not going to work. So there
Mhm.
really needs to be a balance of sufficient job creation, steady, credible job creation that aligns with the size of the investment and scale of the business as well as business progress, so that the immigration officer feels this business will be creating meaningful jobs in a near term. And that if the entrepreneur is going to be involved in the provision of services, him or herself, that it's going to be very short term, and their job is going to be primarily focused on management and strategies and overseeing the business. And within the first couple of years, the business will grow, where the responsibility will evolve, where the E2 applicant is going to be solely focused on management and executive functions, and all service work, provision of services will be delegated to American workers. So, in my mind, depending on the type of business, the industry, I'll have in my mind like the minimum job creation that we want to be able to show to the adjudicator to have a baseline non-marginality case. You don't want to be too small. And if a business is really going to be that small, where they're not going to be hiring anybody for the first 2, 3 years, then I'll advise the client to rethink their business model, because they need to understand what the E2 visa is all about. It's entrepreneurship, not to be a worker.
And on the subject of the financial projections and trying to have them a little bit more dreamy scenarios, and sometimes, clients, yes, they're entrepreneurs and they want them to have really inflated numbers. But I sometimes have to tell them, this business plan and the business plans for E2s are quite different than ones you would write for, investors or bank loans, and we create business plans for those. In that, the audience here is an immigration officer, and so definitely it's a good idea to keep them somewhat conservative, to keep an eye on your renewal point, as you mentioned a little bit earlier. So yeah, that's a great point as well. Um, and then going back to, I guess, RFEs and strategy, what are the most common business plan related RFEs you're seeing today at both USCIS and US embassies?
Yeah. So the RFEs, they're kind of different from USCIS and the embassies. With the USCIS, they focus, like I said before, focus a lot on the source of fund, trail of the money, but also spending of that money, detailed documentation of spending of the investment funds, and that the proof of the expenditure correlates to the actual source of the funds. So they want to see clear evidence tying that money. So in the Journey Business Plan, there's a great section on the use of the funds, the investment expenditure, that details line item of the expenditures. And in a lot of cases where there are extensive amount of expenditures, like for example, recently I had a case where the client had over 300 expenditure transactions, And it was almost ridiculous to create a spending chart with more than 300 line items and corroborating each expenditure, because some of them are like small dollar amounts. So we kind of group them together into like 10 broad categories. We got an RFE on that. The USCIS adjudicating officer actually wanted us to line item the 350 expenditures, item by item, connecting to receipt invoices and proof of payment, item by item by document. So, and we did it. It was a huge response, and we got an approval. But it just goes to show that they really focus on the expenditures. And with the USCIS, because there's no page limitation, we're submitting the entire business plan, 30, 40, 50 pages. So that the business plan become part of the record. And so if you get an RFE that requests detailed proof of the expenditures, they need to line up with all the expense items that is asserted in the business plan. We want to minimize inconsistency. So it's so important for the journey writer to communicate with the attorney to make sure everything is consistent, because there's a possibility you might get an RFE that really digs into every single detail. And if there's any inconsistency, now we're sweating bullets on whether the adjudicator is going to notice that inconsistency. So that's really important that we do that. And then again, like with the financial projection, it's always important to make sure that they line up. Like, if, for example, with an extension or renewal, if the projections are significantly different than the actual performance under the previous 2 years E2 status or 5 years under consular E2 visa, that they make sense that the projections are based on a continuation of steady growth from the previous 5 years or 2 years, or you have a meaningful business improvement or change, maybe expansion to multiple locations or expansion into different product line that would justify a jump in the financial performance projections from the previous years. So that has to be explained and clarified and justified. No longer is it realistic to get an approval with just making blanket assertions of rapid growth without showing credibly details of how that's going to be accomplished and actual action items on to corroborate that expansion. So, for example, if you're saying that you're going to grow a business doubling the revenue in the coming year or two, and it's going to be based on a new location, it's not enough to say that you're going to open another new location. You want to provide evidence of that location being secured, lease signed, maybe the renovation is in progress, and business license applications in progress, so that it's crystal clear that the expanded location is real and will happen and not based on purely talk or words.
So now, have you recently experienced any RFEs or from USCIS or the Department of State regarding the origination and accumulation of invested funds? And if so, how do you typically address those type of RFEs?
Yes. So with the source of funds, bulk of the homework is done way in advance in the beginning of the case to make sure everything is airtight and making sure the client doesn't make any transactions or use any source of funds that's going to be risky. So that if you do get an RFE, you're confident that your response will be very strong. The worst case to be in is where there's a whole bunch of mistakes made with the source of fund, a fund transfer, and then you get an RFE on it, and the response is just basically begging for mercy because it is truly done in the wrong way, such as funds being transferred directly from a third party to the U.S. enterprise without the applicant ever having control or possession of the funds. Or there's a cash transaction where the investment fund source is commingled with all kinds of other funds, where the adjudicator can no longer determine what source of fund is being actually utilized for the E2 investment. So yes, I mean, and even with very careful source of funds due diligence that are always done over the years, and sometimes the clients think I'm crazy, I'm worse than IRS auditor. This past 12 months, sometimes get RFE on source of funds where they're diving into the weeds. They're looking at the bank transfer transaction description language. So sometimes with some country, transferring money out of the country is restricted. You can't just transfer US dollar out of the country for any reason. It's only permissible for limited reason, for education purposes, for living expense purposes. So you have to put in a transaction wire transfer description that the money is for an acceptable reason. If you say it's going to be for a business investment in the United States, your fund transfer from the origin country could be denied. So now the adjudicator is saying, hey, this transaction description is talking about for a completely different purpose than an E2 investment. So that doesn't make any sense to us. Justify that. So then you try to explain, but then you're sweating bullets because now they could accuse you of misrepresenting the purpose of your transfer to the origin authorities. So they're really diving into these kind of weeds, and so financial due diligence is becoming even more important. Like sometimes I feel like I'm a forensic accountant looking at all these documents.
I can imagine.
That's the reality we're dealing with now. Yeah.
And I guess along those lines, I mean, how can attorneys better collaborate, I guess, us as business plan writers to anticipate officers' concerns before that filing? I mean, particularly when facing page limits at consulates as well.
Yeah. So I think one of the misconceptions about consular E2 application is the business plan has limited use because we're only able to include a small excerpt of the business plan for the consular E2 application. To me, at least, that's not true at all. At the consular application, even if I'm not able to include a full business plan in the consular E2 package, I use the business plan in two very important ways. Number one is I use a lot of the details in the attorney cover letter to help me advocate for the non-marginality and the potential success of the business. I'm not a market research analyst. I'm not a CPA. I'm not an accountant. So I rely on the business plan for these type of financial data and market research and analysis and marketing strategies to craft my arguments in the attorney letter of the potential success of the business. So I rely on that. Otherwise, I'm drawing a blank because a lot of times clients are unable to articulate these kind of strategy and details and numbers because they're more of an idea guy, they're entrepreneur. They provide kind of confusing or disorganized information about the financials and the market analysis. So I rely on the business plan a lot for that in my advocacy attorney cover letter. Number two is nowadays the embassy interview is becoming more extensive. I notice the questions are more extensive. Back in the old days, 10+ years ago, or the year that really I noticed the scrutiny ratcheting up was 2017. Like prior to 2017, I was very frequently getting small investments like mid 50,000 or less approved for early stage small startup service businesses, consultancy with no employees, no revenue, and felt really confident in getting approval. I noticed that starting 2017, things changed. The rules didn't change, but adjudication scrutiny and strictness changed. And so now in the past 12, I didn't think it could get more challenging, but last 12 months, the embassy interview questions, even in Toronto, have become more extensive. So now the client's performance in interview is super critical to the final decision. And some clients are great communicators, fantastic. Some are not. Some have poor English. Some have really trouble communicating. And the officer, they have very little patience. They have 5 minutes, 10 minutes, 15 minutes max, or in the rare cases, more time. But they don't have patience for someone that doesn't communicate well. So I advise the client to really study that business plan. Use it as like a study guide, the key preparation material, so that they can become an advocate. I tell clients when they approach the officer at the embassy interview window, treat it as if they're pitching their business to investors. Do not be a boring a regurgitator of facts about your business. The key is to create an emotional transference of the excitement that you have, the confidence that you have in the business potential, and the great future that you see for your business. And that your business plan is not wishful thinking, but they're based on real research, credible projections. And the business plan is a great interview preparation tool in my experience, because it's laid out in such an organized way. Financial performance, job creation, marketing strategies, marketing research, executive summary, summarizing the ownership structure, sometimes their parent subsidiary, multiple ownership partnership, expenditure table. Usually, like in my support letter, attorney letter, I'll break down the investment in even greater detail, line item, because of the trauma dealing with USCIS. But when the client reviews that, that is overwhelming. They feel like, how am I going to memorize all this? So the value I see in the Journey business plan is that the expenditure table is more palatable, is more digestible. So, because sometimes when clients overwhelmed for the embassy interview, then they go into it feeling really anxious. They're trying to memorize so much stuff. It's not about that. It's about being able to communicate properly and conveying that confidence to the officer's mind. And so I use the business plan for that purpose significantly for the embassy. And even though some embassy, the page limitation has gotten so ridiculous, 40 pages, 30 pages, 50 pages, I'm only able to include maybe a handful of pages from the business plan. I still have the client review the entire business plan, because I understand how important that interview process is. And, fortunately, you and I, we've been working together for a decade now. So the benefit of it is I don't even need to tell you guys what I want to see in the business plan. You must take really good notes. Every time I get a draft, I'm like, oh, wow, this is pretty much what I want. And I'm just kind of fine tuning it. So I really appreciate that working relationship, so that I don't have to like re-educate the business plan writer for every single case on what we need to see to make it a credible presentation.
Yeah. I definitely mentioned that we kind of understand your preferences, and over the years, we do have a customization sheet that we understand. Each one of the lawyers kind of have different approaches that we work with. I mean, nowadays we work with maybe over 500 law firms, and everybody kind of cooks their soup a different way. And it's important for us to be able to follow, and make your job easier, and not have to coach us every single time. So I'm happy we could customize it to what you want to see. At the same time, we've learned a lot from you too, Bobby, over the last 10 or 12 years, and working with you. So it's been a pleasure just to get your insights and really also read your comments, um, and your approaches. So I know they're extremely valuable. Um, I, I guess you also mentioned earlier, as far as investment, you mentioned 50K was used for acceptable amount in 2017. I mean, what nowadays is the lowest you would go for a new consulting business?
Right. So yeah, like before 2017, I was fairly confident in most consulate posts with a small investment, even early stage mom and pop businesses. But starting 2017, I've noticed a clear shift in attitude and scrutiny by a consular post. With smaller investments, I've noticed that USCI is still pretty open-minded, even up until today. It's not uncommon I get E2 approval from the USCIS of five-figure investment, 60,000, 70,000, 80,000, as long as it makes sense for the business. It's non-marginal. Some of my clients are able to get great deals on purchasing the assets of the existing struggling business and turning it around. So the investment could be low. But it seems like with the U.S. consular post, if the investment amount has like this significant relevance and impact on adjudicators' perception of the business. And so I'm usually reluctant to present a case below 100,000 at the embassy unless all the entire profile of the business is highly credible. And by that, what I mean is if an applicant has significant success track record, in their home country, in that industry, in that business, and is a seasoned, successful entrepreneur. And they're going to the United States industry that they're quite familiar with. And they're a great communicator. They can present themselves really well at the interview. Then I might be willing to submit a lower investment amount, sub 100,000, for a low cost service business where they can make a really credible showing based on sheer fact of their personal profile. And also, of course, the market opportunity. I'm seeing questions about why have you decided to open your business in this location in the United States? What is the market opportunity in this location in the United States? So I've noticed a lot of real estate development business in Texas, where there is, in fact, objectively, they will research this online. Adjudicators have to understand they do their own outside research and then, kind of validate a lot of the assertions in each application. And if, in fact, the market, the demographics, the product line makes sense, then they're more willing to accept a smaller investment. But, you really have to look at each consular post individually. It seems like I almost see them as like consular posts with different personalities. And some of them are really nice and open-minded. Some of them are mean and they assume the worst. And you almost have to prove they assume marginal, and you have to prove them otherwise. So I've had the experience where we have identical businesses apply with consulates, different consulates all over the world. And then it would be easily approved. And then you see the treatment by different consulate, totally different. Some consulate, easy peasy approval with minimal questions. And then you have the mid-level scrutiny where they ask a lot of questions, still approve it. And then you have consulates that identical business, it's a franchise business or at least a startup service business, where they are unwilling to approve it unless there is already significant business development progress, employee, critical mass of revenues. And it's just amazing how different the consular personalities can be, even for the same business. So, if we really have to interview the client and see their profile, and then look at their business idea and evaluate the credibility of the entire business venture and applicant individually, and whether they have any business partner that brings in strategic value to the venture. And in order to evaluate the denial risk factor for that consulate, for that business model, for that applicant, for the business structure, for the partnership structure. So it's hard for me to say a simple investment amount that would apply across the board like that. But if you force me to come up with a number, I'm going to say the cliche number of about 100,000. So I notice when I give this complicated explanation, a lot of clients or prospects or business attorneys or CPAs, it just becomes too confusing and nebulous and ambiguous. So generally they said, just give me a number, Bobby. I'll say, all right, you know what? Let's try at least 100 grand. It's not written in stone. We can adapt, but let's start with that at least.
Right. And we'll get to these Q&A questions, but I guess one last question, as far as just closing questions, what kind of misconceptions do applicants still have about business plans? And for example, assuming a shorter submission means a full business plan isn't necessary, that attorneys should be actively correcting during consultations.
Yeah, so I alluded to these points before, but I'll just kind of summarize and reiterate. Number one is make sure the assertions in the business plan are credible and lines with the actual investment amount, the size and scale of the business, and the actual results of the business progress so far. They need to align. And if the business is an existing operation, whether it's due to E2 renewal or buying an existing business from a U.S. seller, the projections needs to align with the prior performance. And if there's a big distinction, they need to be justified with hard evidence of the distinction. And the second misconception is that the business plan has little value given the strict page limitation of many U.S. consulates worldwide. Like I said, I use that as a major piece of interview preparation material for my clients, me and my team also use the business plan significantly internally in crafting our cover letter to advocate for the business success and a non-marginality aspect of the business. Like I said, I'm an immigration attorney. I'm not a CPA. I'm not a business market analyst. I'm not a business attorney. I rely a lot on the data and the business plan to develop the content advocacy argument for business success in my attorney cover letter.
Business plans are important. More than just submitting them for USCIS, but as you mentioned, exactly for a little bit of study material, so they know a little bit more about their business. I also explain to the clients, this exercise of writing a business plan helps you understand your business inside and out. And it's kind of important to formalize it and put it on the paper. It's a lot easier to remember, what you're trying to do and what your goals are, because in our business plan, we're going to create benchmarks and milestones where you'll be able to kind of understand where you're headed or where you should. So definitely a critical piece of the application. And again, thank you for your insight there, Bobby, on that was very, very insightful. And thank you again for your trust over the many, many years. And we're happy we've been able to support you for these many years and be able to be kind of your back office and support you and help our clients, most importantly. Is the most important goal is helping the clients get to their goals and having their American dream. Yes, right. All right, so let's get to some questions. Can you elaborate on what you mean as far as extensive questions are being asked at the consulate? The questions being asked for initial E2 visa stamping, are they the same as renewal?
Sure, I'm happy to explain that. So you have the standard questions. Tell me about your business, your investment, your job creation intention, how many employees you have, your financial performance, source of funds. Those are basic questions that have always been potentially asked through the ages. Nowadays, there are more additional questions. A lot of it is focused on security assessment. So the applicant's individual profile, their travel history, what countries have they traveled to? So if they traveled to any of the travel ban 39 countries, that's a red flag. If they're dual nationals, so that's like, okay, you're born in Iran. Did you serve in the military? Do you have family back there? How often do you travel there? How long do you stay there? What do you do there? And sometimes applicants have in their resumes, their work experience, they have work experience involving dual use technologies that could be used for benign purposes or military purposes. They'll get questioning about that. What did you do with that technology? What did you study? Because if the officer is not fully satisfied, they'll decide to impose a security background check, also known as administrative processing, that could delay the E2 visa decision by weeks or months. In an extreme case, I've had a client that had to wait over 2 years because of his Iranian ties, unfortunately, even though he was completely legitimate guy. So a lot of that, they are asking questions about family ties in the United States. How much family ties do you have in the United States? We also have to watch out for a family member involved in the U.S. business. It's not prohibited, but there's seems to be a concern that, is this business venture for real? Or is it just your U.S. family members helping you get the E2 visa so you can live here and work here? This is especially true where the business venture is only a partnership. The applicant is not owning the business outright, but purchasing a partnership, maybe purchasing it from a family member or relative, and they're only taking a partial ownership, and they have little to no background in that industry, and the U.S. partner had significant background in the industry, and they're related family members, and the applicant is going to be living in the United States close to their family members. That could be a red flag of immigrant intent. Sometimes they'll even ask, how did your family members immigrate to the United States? So family member that immigrated to the United States through methods that could trigger immigrant intent concerns. So I always ask this question, like, do you know how your family member immigrated to the United States? If I've noticed, if the immigration involved like refugee asylum or TPS, or any kind of undocumented status. Those are risk factors, and they will like punish the E2 applicant for any kind of potentially for the violations of their family members. So they'll consider that. They'll ask them about their prior U.S. travel history to make sure that they are in full compliance. They did not work illegally. Some common issues with like folks traveling to the United States as B2 visitors or W2 tourists, where they put their kids in school. And that could be a problem because that's not authorized for kids to be attending school as B2 or W2 visitors, right? And also, like, if this is tricky because they're expected to set up, invest and set up the business and create a real active non-marginal business prior to applying for the E2 visa. And a lot of embassy really want to see the applicant already have hired U.S. employees. And then the border CBP officer, they have a totally different perspective. And sometimes when you tell the border CBP that you're here to hire employees, they will accuse you of intention to work illegally. So that's a really tricky advice to give client, where the embassy wants you to hire people. But if you are very transparent about that with CBP, you might get denied entry for accusation of intention to work illegally. So basically, sometimes they'll ask, like, what were your activities in the U.S.? Notice that you stay for 6 months, or you apply for a B1 extension and stay for nearly 12 months before you apply for E2. And the business was operational in the last 4 months of your stay. What did you do? So we got to make sure that they have employees where they can point to and delegate the operational activities to U.S. employees or U.S. business partner. Got to be very careful that there's no even a perception that they engage in unauthorized activities. They're really, really serious about that. And sometimes it's a tricky part where the client runs out of time in initial 6 months authorized stay, and they need to apply for a B1 extension to extend their stay in order to complete their business investment, right? But USCIS a lot of time taking super long time to adjudicate the B1 extension or B1 COS, and they have to depart the United States to go to the embassy visa E2 interview while the B1 extension is still pending, which results in automatic denial for abandonment of application that's still pending. So now they're going to the embassy and they have a denied extension. So I really prepared a client to address that the denial is purely procedural, not on the merits, not because of any violation, and that they carried out the asserted activities in the B1 extension and bring a copy of the B1 extension application stating all the things that they're going to accomplish, and they actually accomplished it, and they had to depart, and the only reason they depart and abandon their B1 extension or B1 COS is because they had to go to the interview at the U.S. Embassy abroad. So that's another area of questions that they're delving into. A crazy RFE that I saw recently, I want to share with everybody, is E2 application where applicant is a dual citizen of Iran and UK, British citizen, had gotten an E2 visa from a London embassy, 5-year visa, came here and made some changes to the business. So applied for E2 amendment, E2 status extension with USCIS. And all the business, everything was satisfactory, okay? The RFE was on sole issue. I couldn't believe what I saw. That you were born in Iran, and because of that fact alone, because Iran is a state sponsor, they sponsor terrorism, this is deemed a significant negative factor on your case. And for discretionary reasons, we can deny you. So you need to prove that you have good moral character. And they gave a whole list of example of proof of good moral character, similar to like a naturalization application, proof of good moral character. Of course, it's not enough to be law-abiding. You have to show that you are a good, productive member of society, and you get support letter from prominent people. And essentially, you're guilty because of where you're born. And it's the first time I've seen an RFE like that challenging the eligibility of E2 status based on the country you were born, solely based on the country you were born. And this is a really legit professional guy who's been living in the UK for decades. So these are kind of scrutiny that we're dealing with nowadays.
Wow, that's It's a shame. Going back, I guess, how a few questions from the Q&A. How does pivoting a business after approval is seen by you? How does pivoting a business after approval, um, how do you consider these cases a new business is related to the original or another case where it is not? I mean, how do you feel about a business that after they get approved for their E2, they pivot to, a different business model?
Great question. If properly done, it could be a very positive thing. By pivoting means that either the original business model didn't work out, and entrepreneur is not giving up. They're looking for new opportunities, they're pivoting to new products, services, industry, markets, and they show that in the extension. That's a great thing. They're not giving up. So as long as the reason for the slower than expected performance could be explained or justified, the pivoting is oftentimes, in my experience, shown as a positive factor for E2 renewal, especially if they're still within the initial 5 years, because the regulation states that the E2 entrepreneur has up to 5 years to prove the success of their business. So if you're still within that 5 years, pivoting is not unusual, and an entrepreneurship changing or mending or pivoting is very, very common. So there's pivoting situations where the original business has suffered and they want to really change. That could be a good thing because it shows the future promise, future viability. It could be the original business did just fine, but they see growth potential in a related industry. It happens a lot in home industry businesses where they're selling complementary product or services and able to market, cross-sell to the same customers, expanding their revenue opportunities that way. Where pivoting becomes an issue is, especially with the USCIS, is where they make massive changes to the business and they wait a really long time before they file the E2 amendment or E2 extension. So they've been operating under the pivoted business that is massively different than the original business. And by the time they apply for the E2 extension, maybe half a year or longer have passed. And there's now a risk the adjudicating officer may say, you requested approval for your changes too late. You should have done it way earlier when you first started making the pivot because we needed to approve your changes. Those are material changes. So it's a question, legal definition of what is a material or not. And I always tell clients after the E2 approval, please, if you're going to make any pivots or major changes, let's talk first. And depending on the scale and extent of the pivot or change, I might recommend that we reapply for a new E2 visa or amended status immediately to avoid the risk of being accused of violating or failing to maintain your status. But if they're keeping the original business, they're just adding additional business, then I feel less nervous about waiting until renewal time to show the pivot.
Yes, that question comes up quite a bit on our end too. And I always point them, you should speak to your attorney about that if you want to change your business. Of course, good business people will come to the US and adapt and understand the market a little bit more when they have their boots on the ground, kind of adjust. But it's something to be discussed with your lawyer, definitely. Um, Another good question here is how do you document in cases where a client invested personal funds prior to forming an investment entity and transferring funds there for USCIS?
So I haven't had much problem with that. So if so nowadays, I've noticed in the past couple of years, it's becoming more and more challenging for non-resident foreign citizens without social security number to open business accounts. A lot of banks are not doing it because I talked to several bankers about it. Why are you guys being so hard about non-resident foreign citizens who are sole owners of a U.S. entity from opening a business account? And a lot of the bankers, VPs, have been telling me that they're experiencing unprecedented amount of fraud and scams. And then the IRS is holding them financially responsible for all these fraud and scams. So they're really vetting their customers. And they're also looking at the nationality of the customers. And unfortunately, there's flat out ethnicity and nationality discrimination there. So reality is sometimes it's not so easy to complete the business formation and the getting an EIN. Now IRS is delaying EIN issuance for company that's solely owned by a non-resident foreign national without a social security number. It could take weeks or months or longer. So there might be a massive delay in opening a U.S. business account in which they can't deposit investment capital until the account has been opened. But a lot of time there might be critical, time-sensitive business startup expenditures, such as paying a franchise fee, such as paying a deposit on a lease, such as paying for inventory purchase deposit. I've never had a problem showing that prior to opening the business account, the client had a credible, genuine, urgent need to pay a business expense from personal bank account. As long as those funds are coming from qualifying fund source, I never had a problem with that. And I would show that as soon as they're able to open a U.S. business account and deposit their investment capital, they promptly started expending their startup expenditures from the U.S. business account. So far, knock on wood, USCIS and the U.S. consulates have not objected to this structure.
And then as far as to say, as to the funds of investment, do they accept reinvestment of revenues generated, or they only want to see the funds originated outside of the business and invested into the business?
That's a great question. That's a great question. And I've done it. And we have to treat that very carefully. Okay. So E2 visa is about investing personal capital into the business. Okay. Sometimes the business retain earning, especially depending on the entity structure. If it's a C corp, for example, the retained earning of the business belongs to the business, and it's not considered the applicant of the shareholders' personal capital until they distribute it, right? Profit distribute and then claim it as a personal income and then reinvest the money back in the business. It'd be different if it's like a disregarded entity where the retained earning is automatically reported as the applicant's personal income. Then I'm comfortable with directly reusing that retained earning for reinvestment in the business and then stacking that reinvestment on top of qualifying investment amount, basically increasing it at the time of each renewal. But if it's a corporate, a C corp, for example, and it's the corporation, the entity is considered a separate legal person, then I will advise the client to draw that money out and claim it as personal income and pay the personal income tax, report it on their U.S. personal income, and then reinvest the balance into the business to make it clear that this is a contribution of investment capital. Of course, this sucks because they have to pay income tax on that, and so they lose some of that earnings. So what I tell clients is, look, if your original investment that we got you qualified for the initial E2 visa is still adequate, and there's no really critical need to increase your qualifying personal investment contribution, then just reinvest your money from the corporate earnings. We may not be able to credit that amount toward personal investment contribution. I'm still going to mention it in the E2 renewal that you reinvested corporate earnings back into business expansion growth. It may not technically qualify as personal capital contribution, but it's going to have secondary value to the adjudicator. I just won't add it to the total calculation of a qualifying E2 investment, but it still has value. But if it's a disregarded entity, it's a different analysis.
Yeah. And another good question regarding dual nationals, E2 processing and USCIS. Have you seen that it is applied? The administrative pause for banned countries, regardless of the passport used at entry, is not from that banned country?
Yeah, so this goes back to the example I gave with the Iranian dual national British Iranian client. So your nationality, as far as U.S. immigration is considered, is the passport you utilize to enter the United States. So whatever nationality you're admitted into the United States, that's a nationality that controls your qualifications for E2 treaty status. So as long as you enter the United States with a treaty qualified passport, you can apply for change of status E2 and apply for E2 status extension. And it's never been a problem historically. It doesn't matter if you're born in another country. But nowadays, with this 39 partial and full travel ban countries, it's in the RFE example that I mentioned with the Iranian dual national, the adjudicating officer actually acknowledged. So adjudicating officer actually quoted the presidential proclamation from 2025 banning the travel of certain nationalities, quoted that as justification for accusing my client of having significant adverse factor because he was born in a country that sponsored terrorism, but acknowledging that that proclamation does not apply to individuals already in the United States changing status, only applies to folks outside the United States. And in fact, proclamation exempts dual national, meaning that if you are applying with a non-restricted nationality, you're not subject to the proclamation, the travel ban. So the RFE acknowledges that, but it nevertheless say we have discretionary power and we're going to use that here, and we're still going to use your birth country as a significant adverse factor in our discretionary decision. And so we now, as immigration attorneys, now we have to take dual nationality much more seriously and really analyze it. So recently I had another case where the client is a European passport holder. But because his dad was a diplomat in Libya 50 years ago, he was born in Libya, but left Libya when he was a little baby, never had Libyan citizenship, never really had residency, never went back. And when he applied for E2 visa, everything was great. Officer was satisfied. Officer said, however, you were born in Libya. And of course, he clarified, look, my dad was a diplomat. That's the reason I was born there. I have no connection to it. I left when I was in diapers and never been back. Officer said, we're going to have to do security background check on you. You're going to be under administrative processing, 221G temporary denial, refusal. So I had to call my client down. Don't worry. Let them do their thing. They're not going to find anything. So they just got to go through their paces because there's a directive by the State Department headquarters that they impose security background check on these dual nationals, especially ones that have any connection to those banned countries. So yeah, we have to be very cognizant of the impact of dual nationality and all the things I mentioned earlier about their ties to that country. They're going to analyze that now.
And I know we're a little bit over, Bobby, but we have some really good questions. So if you don't mind, maybe a few more, and we can wrap things up. How would you manage if the business moves from one state to another while an E2 managerial employee COS is pending? Is this material change that could affect the case? The company is incredibly successful both financially and with hiring USC LPR.
Okay, great question. Great question. So usually a relocation into a different state could be seen as a material change. Of course, over the years, I had clients that they did it without telling me. So when we apply renewal, I'm kind of sweating bullets because I know that could be perceived as a material change, but we got an approval anyways. That was with the consulate. They tend to be more lenient on that kind of stuff, but I wouldn't push the envelope with that. So with a relocation change, if it's a lock and stock, complete move to a different state, I'm going to err on the side of caution and treat that as a material change and advise the client you need to apply for an amended E2 ASAP to avoid the risk of denial for failure to maintain status. I think the question is making the relocation while COS is pending. I never like and I never recommend major business changes while a E2 is pending. Here's why. They're making a decision based on the facts presented in the petition to the USCIS or to the consulate. If there are significant change, we are obligated to inform the USCIS and the embassy of the significant change because the basis for which we're seeking E2 qualification has changed. They need to factor that into their decision. So whenever you have this kind of change and you need to interfile, affirmatively inform them, you don't know if your documents are going to reach the file with the USCIS. I've done interfile before and it's hit and miss because you're not responding to an RFE, you're affirmatively notifying them. And you don't know if it's going to get there. They could adjudicate it based on the old facts. So I tell a client, please try to hold off. Maybe we'll do premium processing, get a faster decision, hold off on the change. And with the change, if it's a lock and stock move to a different state, I would interpret that as a significant material change If it's like an expansion where you're keeping a presence in the original location that you presented to the immigration authorities, but you're just expanding into an additional location, I would be more comfortable treating that as a non-material change, where it would be palatable to explain at the time of renewal extension. But making significant business change while an extension or COS is pending, or even consular application is pending, is a complicating factor. And then, you can have the client, if consular, you can have the client bring the new evidence to the interview. But then the thing is, now you're risking potential delay to the decision because officers thinking, I need to review this. I haven't had a chance to review this. Or you pre-submit it to the embassy. But with the USCIS, the interfile process, it's hit and miss, and I don't recommend it. So if it's possible, I would advise the client to hold off on that until you get an approval. That would be the safer way. Yeah, and it's also like when you renew the E2 in the future, and they see that the change occurred, even if you get it approved based on the facts asserted before the change, and you apply for the extension in the future, and they notice the timing that you made a change while the prior COS was pending, and you did not inform the adjudicator of the change, and they approved it based on inaccurate facts, that could impact future extension approvals as well. So I would, advise the client try to hold off if possible.
All right. Thank you, Bobby. A lot more questions out there. Not sure we have enough time for them all.
I know.
I wish we could get to them all. I know that you gave a lot of context and a lot of insightful, valuable information. Hopefully we can have another webinar that can be a continuation sometime soon, but I appreciate you being here today, Bobby. Really, really, really good information and a great webinar. So thank you for spending your time with us. Appreciate you.
This was a lot of fun. Thank you for having me here, and thank you to the audience for being here. I know you're all colleagues, so hopefully I gave you guys some value sharing my experience, and I would love to do this again. This is a lot of fun.
Yeah, I think that we have a good chemistry here now that we kind of understand where everybody's coming from and the dynamic, how this webinar works. Maybe we can have one of those kind of a Q&A open forum kind of questions, and maybe get to all the kind of questions that people would like us to answer, and a little bit more insight on those subjects. Would love to do that.
Awesome.
Thank you, Bobby.
Awesome.
All right.
Absolutely.
Have a great day,
Take care,
Bobby. Thank you
everybody.
for spending time. Have a good day, everybody.
Take
Thank you for
care.
attending. We appreciate you as well. Bye-bye.
Bye.